behind this leniency program is, number one, to get information from whistleblowers. Whistleblower would mean anybody who has information on the modus operandi, who has information about any cartel being operated, who has documentation related to that, including a person who has been involved in the cartel. The intent basically is to identify and investigate cartel cases. So CCI, of course, realized when it was investigating a lot of industries that there is a need to identify cartel. Formation of a cartel led to price variations, led to manipulation in pricing in various industries, like airlines, cement industries, tire industries, several industries as a combination when the industries came together and got involved in a cartel in one form or the other, in the form of probably being part of an organization or an association, etc., where this information was exchanged between the parties about pricing, about the products, etc., and where that information was used by the cartel to manipulate the pricing, it was harmful in general for fair competition in India. It was, of course, a restricted trade practice. It is a restricted trade practice, and which also led to the end consumer being hurt by this cartel, because then it became subject to manipulation of the pricing. The intent, like I said, behind this was to reduce that and to encourage parties to come forward to give information about this, and thereafter to investigate the cartels and put together a mechanism to remove these practices. These leniency programs basically are governed by Section 46 of the Competition Act, and there are also regulations which are the lesser penalty regulations which have now been formulated. In terms of the regulation now, the first informant, as we may call it, that's a very loose word I'm using, the first informant or the applicant who applies for the leniency program first, could be entitled to 100% reduction in the penalty, which otherwise would be at least 3 times the probably the last several years of profit, etc. We know the penalties that are there under the Act. So you could get either 100% exemption from that penalty, or the second applicant would get a 50% exemption from the penalty. The third applicant can get about 30% exemption from the penalty. Now, the Commission can grant these exemptions based on various factors that they have actually laid out. Now, these various factors are such that they are very objective. Number one, the leniency program is not a matter of right. It is a matter of the discretion of the CCI, and it can be revoked at any point of time. The leniency program basically is granted or is favored in favor of a person who actually will give all the details of the members of the cartel. So if you're the first applicant, you're required to give all the details of all the members of the cartel, then the objective of the cartel, the modus operandi that has been followed, then you need to give a description of the product or the service, then you need to give the geographic coverage of where it has operated, the duration within which the cartel was present, all the details about the communications and the meetings between the parties, and any other information that may be available with the applicant himself. So it's a very strict regime that has been laid out on what would consist of, what is required to be contained in the application made by the applicant for availing such leniency programs. Now, what is the process for applying to the CCI for leniency? Now, once an industry or a particular individual even, and now individuals have come into the foray of the leniency program by an amendment. And individuals as well as companies, once they realize that they are part of a cartel, can make a marker application with the CCI secretary. This marker application is nothing but a token application, which is for the purpose of registering their interest for the leniency application. Now, the marker application is sent to the secretary of the CCI, either by email or by post, etc. And within 5 days, you will get an acknowledgement related to the submission of the marker application. Once the marker application is given, you will get something kind of something called an intimation related to the priority status. Now, this intimation of priority status generally you would think would show you whether you're the first applicant, second applicant, or the third applicant. But this first stage intimation does not include those details. It does not give you the rank of the applicant, whether you're number 1, 2, or 3. It only records the date and time of the receipt of the application. Once you receive the receipt, within 15 days, you must file a detailed application with the CCI with all the relevant information and the evidence regarding this entire cartel activity. If this application is not filed within this 15-day period from the receipt of the acknowledgement, then your priority status, you may lose your priority status, and the benefit under the leniency regime may not be available. Now, simpliciter granting the priority status, even as per the regime, does not entitle you to lesser penalties. The reduction in the penalty is going to be determined by the quality of the evidence that you have actually furnished. Now, the quality of the evidence will get to what kind of evidence is required to be given, and I have touched upon it, that it has to be material evidence. It has to be evidence which shows the duration during which the cartel took place, what was your role in the cartel, the information that has been exchanged by the cartel, which geographic locations the cartel has been operating in, etc., which actually facilitates an investigation by the CCI. That is what the CCI will look at. Whether most of the corporates, I would think, would be very wary of getting into a leniency application for the simple reason of confidentiality. Also, there are several hurdles, of course, why a corporate or an entity would not want to file a leniency application with the CCI, including the fact that it's not a statutory right, but it's a conditional, and it's a power given to the CCI to grant it or not. But one of the factors that is very important, I would think, is the confidentiality factor. Now, and any application made to the CCI, we must bear in mind, is confidential in nature, unless it is required, and all the general provisos will apply, unless it is required to be disclosed by law, or if the applicant itself, grants CCI the liberty in writing to make such disclosure, or there is a public disclosure of the leniency application by the applicant himself. Now, what are the obligations once you file a leniency application? A simpliciter filing of a leniency application, giving all the evidence vis-a-vis the cartel, giving the information regarding the cartel is not enough. What is it that the applicant requires to do? One, after submission of the leniency application, you have to make sure that you are not part of any, you don't further participate in the cartel. You provide all the disclosure related to that. You provide all the information related to that. You cooperate with the CCI, and the DG, and more importantly, that you do not conceal, destroy, remove, or manipulate any of the information and records that are available to you. Also, the CCI has the power to impose additional restrictions on you on what you can and cannot do in pursuance of that application. If you don't comply with the obligations that are required under law after filing of the leniency application, the CCI may revoke your benefits under the application, which is why I think the leniency program has not been a great success, except a few cases. I don't think many parties have actually, as per the last records also of the CCI, not many parties have actually fallen into the regime or have cooperated and filed substantial leniency applications, because the regime is so strict. And one, the regime is strict. Number two, it's conditional. Number three, it requires a lot of conditions to be followed. And nobody would want to, of course, acknowledge the fact that knowingly or unknowingly, the intent is irrelevant, that they've been part of a cartel. Then comes, we've looked at how they are going to look at the leniency applications. What are the ingredients that are required for the purpose of the leniency application? Now, what are the protections and rewards that are put in place for the purpose of whistleblowers? So basically, the Whistleblower Protection Act protects the whistleblowers from any, confidentiality clauses are there, or any willful misuse of power or misuse of discretion, etc. So the whistleblower has been protected from the perspective of the statutory regime to ensure that no harm is done, and that there is an encouragement of the whistleblower to come and to report the, as you say, illegal activities to the required forums. Any questions in relation to leniency applications? I'll be happy to. I think I have very bad timing post lunch. Does anybody have any question related to this? Yeah, absolutely anything that you would want to know or would want me to clarify in relation to leniency application, even thoughts for that matter, on what do you think are the hurdles? And you all are all individuals either practicing in the field of law or working with corporates. So in your view, do you think that you would be interested in a leniency program with the CCI? I mean, I just want to open this up so that we can, discuss the effectiveness of a leniency program.
No, as you said, Suman here, as you said, that this gives an indication that you are at fault. So that is the one thing which corporate and organizations are not very keen to go there. And then there is no clarity that, okay, if you have applied for leniency, then they would accept it. So you are not getting any benefit out of it. You lose the chance of defending yourself, and then you have to prove a lot of things. So that, in my limited knowledge, is the hindrance for this.
Correct, which is why I think it has not really been a commercial success. I agree with you, Suman. Like I had said, if I was advising a client on whether to litigate in a matter like this, where there is a cartel investigation or file a leniency application, my natural inclination, given all the guidelines that are there in the leniency programs and the checks and balances and the conditions that the CCI would impose on them, I would advise a client probably not to go in for the leniency program.
Yeah, correct.
Right. I think we'll look at the CCI and what are the roles and the powers. As we know, CCI has become like a monster today, and it has actually transgressed all industries. It has left no industry untouched, and it has, it's become a really powerful judicial forum, and for the purpose of looking into anti-competitive practices, and it had looked at it is perversed all kinds of industries today. So let us look at what CCI is responsible for. This is very basic, but very important to know of what is the role and what are the powers of the CCI. Now, as we know, the intent of the act is to look at anti-competitive practices, is to look at um, the fact that the anti-competitive practices don't lead to a detrimental, appreciable adverse effect for the purpose of consumers. And just to go back to some discussion which was going on in the morning when Samina was talking about this, of whether the CCI is required to look at only the end consumer, or is it supposed to look at even the industry, which it basically the subject matter relates to. the CCI has a twofold responsibility in pursuance of the act at least. Number one, it has to look at whether the the actions or whether the violations affect the industry, number one, and then whether it affects the consumer at large. Though the CCI has been largely looking at matters where the end consumer is affected, but yes, it is the primary responsibility of the CCI to look at the the effect on competition itself, including entry barriers, including the smaller players in the market, to see whether the other the other industries and the other establishment in the particular market are affected or not. So, in theoretical terms, the CCI is responsible for eliminating practices which have an adverse effect of competition, to promote competition per se, and to protect the interest of the consumers, and to ensure free trade by other participants. So that includes the other industry members. They also are required to investigate into the alleged contraventions under section 3, 4. We've looked at, Samina has looked at 3, she has looked at 4, she has looked at 5 for that matter. So they are supposed to, they have all the powers, and they are required to look into the alleged contraventions on basically either suo moto or, and CC has taken up a lot of matters suo moto also, or on receipt of an application by a party. Now, whilst CCI looks at contraventions, the major litigation, as you see and as you hear about, is under Section 3 of the Act. Section 3 of the Act, where certain agreements or certain acts basically are prohibited, which would lead to an appreciable adverse effect on competition. Now, what is the framework of an appreciable adverse effect? What is it that CCI has to have regard to? The CCI has to see whether the actions as well as the agreements and or the agreements basically will create any barrier in the market, whether it will drive the existing competitors out of the market, whether there will be a foreclosure of competition by hindering entry into the market, whether there is any accrual of benefits to the customers, whether there is an improvement in the production or distribution, whether there is a promotion of technical, scientific, or economic development. These are the several factors that CCI has to look at, and there is no priority between these factors. It is not as if creation of entry barrier is a priority, the consumer part is a priority, but largely that is what it looks at, because the consumer is always the end result. So a combination of all these factors will be relevant for the purpose of CCI to investigate whether the agreement or the actions of the parties will lead to an appreciable adverse effect on competition. Abuse of dominance position. Now, Section 4 deals with abuse of dominant position. Section 3 deals with the appreciable adverse effect. Now, for looking at abuse of dominant position, what would the CCI look at? The CCI would look at what first is the market share of the enterprise, what are the size and resources of the enterprise, what is the size and importance of the other competitors in the relevant market, what is the economic power of the enterprise, including what commercial advantages it has over other competitors, what is the vertical integration of the enterprises or sales or service networks, then what is the dependence on of consumers on these enterprises, whether there is a monopoly or dominant position which is acquired as a result of it being a public sector undertaking, etc., which we have already looked at, whether there is an entry barrier because of regulatory barriers, financial risk, high cost, whether there is a countervailing buying power that is obtained, what is the market structure, the size of the market, what are the social obligations, what is the advantage that is gained. All of these factors put together are required to be looked at by the CCI based on the facts of each individual matter to see whether there is an actual abuse of the documentation. We have already seen section 5, which deals with control and how CCI would look at control and an acquisition of shares. So that is another factor under section 5 that the CCI looks at, and that is the obligation of the CCI. Now, what is the benchmark for the CCI to see whether there's an appreciable adverse effect? CCI will obviously look at the actual and potential level of competition that is there, then entry barriers, we've already said that, then what is the degree of countervailing power in the market, etc. We've already touched upon that. So that basically is the framework of looking at the appreciable adverse effect. Sorry, I think I came back to the subject matter. So the CCI has the power to look at all of these factors under 3, 4, and 5. The investigative matters are under section 3, 4, and 5. And CCI is entitled to grant injunctions, can impose penalties, can recover penalties, can direct parties to, you know, cancel the agreements that it has, modifications for the purpose of section 5. The CCI has a wide range of powers, not akin to a civil court, but as a civil court would have otherwise. Now, what are the remedies under the Act for restoring the competition and penalizing that basically are provided for? The remedies are by directing a cartel. So this is what the CCI can do, like we said, amongst other things like injuncting a party, penalizing a party, etc. They can direct the parties to discontinue a cartel arrangement or an agreement. They can ask the party to modify the agreement. Then they can ask the parties to follow or not to follow a particular practice to give in terms of an injunction. They can impose penalty payments of costs. As we know, the penalties are as high as 10% of the average turnover of the last 3 years, which in many cases runs into crores of rupees. So the CCI penalties, unlike other statutes and regulations in India, are extremely high. Any questions on what CCI can do and what are the powers of the CCI? I mean, I think we're very clear about that, and the statute, there's no ambiguity in the statute related to that. But if anybody wants to understand what kind of preventive practices or the orders the CCI can pass, like I said, simpliciter like a civil court, injunctions, penalties, directions related to doing or not doing something, cancellation of agreements, modification of agreements, all of that would come into the purview, under the purview of the powers of the CCI. Samina has also touched upon the fact that the appellate authority now, after the passing of the order of the CCI, is the NCLAT. It has come under section 53A of the Act. The appellate tribunal now has come under the purview of the NCLAT, who looks at the appellate matters that come from the orders of the CCI. And the NCLAT disposes of the appeals related to the CCI orders that have been passed, including adjudication of claims for compensations that might arise out of the CCI orders. The penalties. As we have seen, the penalties are under sections 27, 28. 27 deals with what are the inquiries related to the dominant position. Section 28 deals with division of enterprise. Section 31 is what are the orders that can be passed on commissions. 32, what is the adverse effect on competition in India, which is taking place outside of India. The CCI has the power to even investigate that of acts that are taking place outside India, which basically will have an appreciable adverse effect on competition in India. The fine amount is 1 lakh each day during such non-compliance. If there's a CCI order passed and that is not adhered to, the fine is about 1 lakh per day for each day of non-compliance of such orders, and with a upper threshold of 10 crores. The fine is, there is also the power with the CCI to punish with imprisonment, which can extend to 3 years, or fine, which may be of about 25 crores or both.
Has CCI given any such decision or verdict in case of imprisonment till now?
Till date, the CCI, the process is that the CCI has to refer the matter to the magistrate. And so far in my practicing time, and I have not come across the CCI penalizing anybody by imprisonment so far. These have only been orders related to penalties and related to payments of fines. But they have not exercised their right for imprisonment. You're right. It's a good question to ask. Now, how do you protect? I mean, the next subject matter that we need to probably touch upon is how do you protect your business?
I have a question. Sorry to interrupt. I have a question. Supriya, this side.
Yes, please. Yes, Supriya.
I wanted to ask, so the penalty which the CCI puts in, it's for the India entity or it will apply to the entire group entity?
No, in what it depends on what is the subject matter of the investigation. If the investigating party, so like I said, you're talking about a case where the a contravention has taken place abroad.
So if it has happened in India only, so how it will be treated? It will be a global, like the entire entity will be penalized, like the 10% of the or turnaround of the entire entity, or just the India entity?
So not as a group, it would be like we know that the investigating authorities and whichever is the entity, the legal entity who is before the CCI, which is being investigated, if the group as a party and as separate entities are part of the cartel, then yes, the CCI has the power to actually penalize all the group companies. But if the single economic unit is involved in the cartel, then it would be only that particular entity which will be.
Okay,
Does that answer your question, Supriya?
Yeah, it does. It does. Thank you.
Right. So just moving on to the next subject of what can we do to protect the businesses? How do you resist the enforcement of a contract that you have in companies? How to make a complaint to the CCI wherever required? What are the actions, injunctions, and damages that can be granted? Let us look at that. As we know, the Act actually prohibits any agreement related to either production, supply, distribution, storage, acquisition, or control of goods, etc., which is likely to cause appreciable adverse effects. So, like Samina has already covered, that you should be very careful and you should do a regular review of the agreements to see that they don't fall within the purview of. It's a very thin line to walk on, and as officers of corporates and officers working in a corporate where business uh, prevails, and it is the most important thing everywhere. As legal officer, it's very difficult to do this review, but it has now become very important for you to look at the agreements from the perspective of section 3, 4, and 5 of the Act to ensure that it is not likely to lead to an investigation. You should make sure that your agreements are not anti-competitive. Then you should not involve yourself in any cartel activities. As we know, marketing, advertising professionals of a corporate tend to, get together. A lot of associations and, organizations are there where they interact with each other. So you will need to sensitize, as legal officers need to sensitize your officers of what the pricing information being confidential, that not being discussed, or that not being used for the purposes of manipulating the market. And we've seen that a lot of industry and the participants in the industry tend to do that. A major player in the market is an airline. Like, you see, if you go to absolutely any website, you go to Make My Trip, you go to Go IBO, you go to any website, the minute you put in a search result, and Samina did touch upon this, that digitally how the manipulation is taking place today, that if you put in a search of a particular flight from Mumbai to Goa, you will see that most of the prices are matched for most of the airlines. How does that happen? Because there is an algorithm that each airline has, which would throw up these searches to them, and then they would be able to price match, so that and in certain cases even increase the prices. Like in a particular scenario today, if you see, for students coming from Ukraine, the prices of airfares have gone up humongously, and it is uniform for all of the airlines, because each airline then would try to you know uh, look at the price and to match the price, and that actually leads to detriment to the consumer, because then they end up paying higher prices for products which otherwise could not be manipulated, and would have then be priced with a very different specification. So we have to be very careful that you're not um, indulging in these practices, which have been looked at CCI very seriously and can be anti-competitive in nature. Now, I think more interestingly, which is probably my area of interest, would be to discuss some case law that the CCI has come up with, to look at certain case laws of how CCI has looked at sections 3, 4, and 5. And I think Samina has partly already dealt with all of this, but I would take up a few of the cases, and I would like you all, if anybody of you all have been part of any CCI investigation or have participated in any such litigation, I would be very, very interested to know. So let us look at a case of the CCI versus the Coordination Committee of Artists and Technicians. This is related to the music and film industry, where on an application from one Mr. Sajjan Khaitan, which was filed against the Motion Picture Association, the CCI had investigated the matter. The investigation was regarding limiting and controlling the distribution and the exhibition of dubbed TV serials. Now, in this case, the CCI had looked at the aspects of whether there was actually a restrictive practice that was involved, and whether the association was actually limiting. So they had looked at various factors like entry barriers. Is it creating entry barriers? Is there this entry barrier and the conditions which are imposed by the motion picture association, whether that is actually creating an appreciable adverse effect, whether section 3.3 has been affected. So the CCI basically passed this order, which then went into appeal to the Compat. In Compat, the CCI order was set aside, holding that the CCI had actually committed an error, that it was guilty of contravention. It went to the Supreme Court, and Supreme Court said that to ascertain whether there has been a contravention of the act, there has to be in place an agreement in the first place, which is referred to in section 3. One, there has to be an agreement. Two, you have to ascertain whether the party against whom the complaint has been filed is actually an enterprise as defined under the Act, and whether it engages in any economic activity. Now, an economic activity would mean any activity which involves profit making and economic trade. Number four, whether that entity actually had power over the marketplace. And the Supreme Court in the present case held that the association itself was engaging in non-profit activities, was hence not an enterprise within the purview of the Act, and therefore could not be subjected to the regime of the CCI. So very interesting findings. I mean, when you file, primarily people would think that if there is any kind of restrictive trade practice that is prevalent in the market, you can just go and file a CCI complaint. But that's not such. You have to look at the purview of the legislation and see whether this forms within the part of and the purview of the CCI at all, because CCI has in a number of cases related to either the banking industry, the telecom industry, held that most of these industries are regulated by a special authorities like TRI, banking finance, there's IRDA, and these authorities have the power to regulate competition as well as deal with complaints related to that, and are the appropriate forum you should go to. So that is one part of it, of what would be the appropriate forum. Even if you go to the CCI, you will have to be very careful of whether you fall within the purview of whether the party which is being complained against falls within the purview of the CCI. So complicated law and several aspects and nuances to be looked at by the CCI as well as the complainant, which the CCI has done very well. I think over a period of time after the um, Act has come into play, the CCI has clarified quite a few issues, clarified and in some cases even confused a few issues of what would be a appreciable adverse effect, and what would be a combination that affects competition, and what would be a agreement that is in violation of the provisions of the Competition Act. Just looking at another interesting case here of, I think the telecom industry is the most popular amongst the CCI. Telecom, as well as recently even the tire industry, the airline industry is very popular too. And Samina did touch upon that there are specific industries where the CCI is extremely intrusive today, and this intrusion has led to more due diligence, requirement of more due diligence in industries. Another interesting case that we could discuss here would be CCI and Bharti Airtel, where Reliance Jio had actually, when it was newly, so this is like, ulta chor kotwal ko kaate is what I would say, when Reliance Jio came into the purview of the industry and it wanted to become a market leader. And not, of course, taking any sides, but it had filed a complaint against Bharti Airtel and Vodafone and Idea Cellular, and alleged that they were basically engaging in anti-competitive activities to try to block Jio from entering the market. The questions which were looked at there were basically whether, and there were several issues that were raised by Jio, to the effect that they were not being allowed to the portability convenience. Their customers, the Bharti Airtel, etc., were refusing to grant portability for the same number, were not being allowed to. Cellular problems which were there, it was blocking their calls, etc. And this had led to actually an entry barrier into the market. and the CCI had actually held in their favor that this would be considered as practices which are entry barriers.
If can I ask you one question?
Yes,
If
please. Yes.
that is the case, how these there are website portal which allows you to pay something and then your firm name or your product will top up appear in the top. Suppose I pay something, does it not fall under that category?
So basically, this you're talking about search engines, right?
Search engines, yes.
Right. So Google, as you know, popularly has this practice, which has been investigated and which also, is kind of, you're right, it is kind of anti-competitive, where Google actually sells these rights to particular individuals. That if you search for an airline, there is a particular airline which will pop up. If you search for a particular industry, there's a particular industry or payment gateway that will pop up. And Google was being investigated for these kind of practices. And yes, that would be considered as an anti-competitive practice. If you're digitally manipulating a space for another competitor to be highlighted over the other, that would fall into the purview, of course, based on the evidence that is available with the complainant and the facts of the particular matter itself. I would think personally it would be considered as an anti-competitive practice. Does that answer your question?
Yeah. Can you throw some light on this Maruti case with the CCI, which had
You're talking about Hyundai Motors, or?
yeah, Maruti, Suzuki and the CCI? Last year, there was some news that CCI has imposed some penalty because they were making some restricting their distributor to offer some discount to the consumer.
Correct. So basically, a major of the investigation was related to this. They getting information that you are actually restricting the dealers of competing brands into entering into dealership agreement. And there was a fixing of the maximum retail price and the maximum discount that can be granted through these dealers
No,
to the
what I
particular.
could, sorry to interrupt you, but what I
Yeah.
could understand that Maruti dealer A was offering a higher discount to the Maruti dealer B if in the same product, Maruti itself. So Maruti has asked that dealer and taken some action on dealer A who was offering higher discount, and that dealer A went to the CCI and there was some this thing.
Correct, because what Maruti was doing is that it was asking the dealers, right, not to offer a particular. So they had this formula where there would be uniformity of discounts that dealers could offer to consumers. Correct, which
Yeah.
led to, correct, which basically was held to be, and they asked them not to do that because that created a marketing issue as well as a revenue issue for Maruti. So the CCI looked at it and it said that you should not, I mean, this is a restrictive trade practice, and the dealership agreements cannot restrict the amount of dealership offers, or because that is an independent business that is done by the dealer, and Maruti does not have any power to restrict those dealers from doing business or granting any offers or discounts to the consumers if that does well for the business, because otherwise it would be restrictive of their right to do the business as they want to.
No, but if I can I take a view that suppose my dealer is offering, he's using his dominant position, he's having the larger sale, so he's offering the extra discount and not allowing other parties to operate in the market, and in terms he's disturbing the market. So can a company can take action on that such dealer?
I would think no, for the simple reason that for one, what would be the relevant market, right? The relevant market would be whichever is the industry that is there. Number two, who can be the complainant in a case like that? Is it the company who is offering the dealership and saying that as a consequence of he granting the dealership and the offers in the dealership, other competitors are being affected, or will it be the
Other,
other competitors who would be entitled to go to the CCI? If the other
other,
competitors
other
and
competitors,
dealers,
other
right,
dealers are complaining to the company.
to the company, probably the company would not be the appropriate party to file this complaint. The
No,
dealerships would probably
but
be the
my
right.
question, okay, company is not filing the case, but can company take some action in that case to the dealer?
Yeah, through the dealers, yes. I would think yes, you could possibly, if there is, it will also depend on a lot of factors as we know. One is the market share. What is the
Okay.
market share of this dealer vis-a-vis the others? Whether
Hmm.
it is actually in a dominant position. Being in a dominant position, as we all know, is not a violation under law, because the intention of the act is to promote healthy competition. So you can be in a dominant position, and it is always going to be that there will be certain entities which will be in a dominant position in the particular market. But whether you are abusing that dominant position is the test. So if you can show that as a result of the dominant position that that party is in, the competition is getting affected, the other smaller players are getting affected, the other dealers are getting affected, I would think you can still make out a case.
Okay. Thank you.
Hello. Hello.
Yes, yes, Mr. Lam.
Yeah. Good afternoon, madam. I'm Ilango from Chennai.
Right.
Actually, I'm running a small ISO certification body. All over the world, major certification bodies, they started an association. It is called the IAF, International Accreditation Forum. They're not in India, but they are abroad. So what they are doing is, in their website itself, they are telling that IAF is the single window recognition system. Like that, they themselves are recognizing. And they are telling that others are not, it means that others are not recognized. So this is going on for the last 20 years. Now, all of my customers are asking for IF membership. Are you not IF member? So this is creating a marketing pressure for me, as well as a small certification body like us. So is it not a, how to deal with that?
Right, I understand what you're saying. So this is an entity which has been formed abroad, Mr. Lango, that's what you're saying.
Yes, yes, yes. Formed in abroad.
Can you please repeat your query, Lango? Sorry.
Sir, I am running a certification body, ISO certification body in India. I'm a small vendor, small certification body. But many certification body like me, they are a very old certification body. They formed an association, International Accreditation Forum. They are registered in USA, and they do not have any office. And what they are claiming is that they are the single window recognition system. They themselves are telling that the member of IAF is only accredited. The member of IAF is only valid. Like that they are telling. And the people with their membership, they are promoting in the market that no, IAF is the recognition body, like that. How an association become a recognition body? So this is affecting small vendors like us, and we are severely affected. We are not able to do the business. Once we did the business also, after some time, my competitors are going to my customer that your certification body is not a member of IAF, so it is invalid, something like that. Even it is went in such a height that even government also believing that IAF is a recognizing body. Even the medical device rule, in that rule also, government has mentioned that the certification from IAF is only valid, like that. It has gone to that height because they do not know what is IAF and they do not see all these things. Even my poor customer, they are also not seeing. We are always arguing that how an association become an approval body, but they are not minding it. It is giving a lot of pressure for me to run my business. That's the reason I attending in this program also.
Right.
How to deal with that? Yes.
So, Mr. Lango, from what you tell me, I think your problem is much larger than the Competition Act. for the
Okay.
simple reason of what you mentioned right now is that even the government has recognized this association as a affiliation body, right? Under what provisions, under what guidelines, we do not know, is what you're suggesting. So if that be the case, my first question to you was going to be to even ascertain whether any provisions of the Competition Act will be affected. I understand that the smaller players in the market are unable to access, the market because of this restriction of having affiliation to this body. Now, what are the terms and conditions for joining this body? I'm really not aware of, because several factors will go towards whether a challenge is maintainable or not maintainable. One is we have to look at what are the factors for the purposes of registration to this body. Number two, whether this body has been, and that was going to be my next question, whether this body or association has been recognized at all by the Government of India. If it has been recognized by the Government of India, on what grounds, on what are the guidelines related to this recognition? Number three, how is actually the competition affected, for the simple reason that who are you dealing with? Who is your end consumer, Mr. Lango, today?
B2B customers, all B2B customers who are getting certificate from me, ISO certification.
Okay. So you have B2B customers, and they would be the relevant market for your purposes. Yes. And because you do not have this registration, they basically, it's a loss of business rather than, an entry barrier, I would think.
Both. It is entry barrier also, because I'm not able to enter into some market, and loss of business also. Both are there.
Okay. But the most important question, Mr. Lango, in your case, even before we analyze the competition aspect of it, is the fact that the government has recognized them as a body. Now, if government in a particular notification has notified this body as legally affiliated body, then you will probably first have to look at challenging the notification itself before you even get into a CCI complaint, because you will have to look at what are the conditions under which the government has come up with the notification. What does the notification relate to? In what context has the notification considered this association as an affiliation and a recognized body? All those factors will have to be considered. And if it is found that there are no guidelines, no appropriate guidelines based on which the government has actually taken this decision, the notification itself can be then challenged.
No,
which would be the appropriate route?
Yeah, I checked with all the government bodies and all. Actually, there is no notification or circular that the certification body should be the member of IAF. No,
but
nothing
you
is
said
available.
there was some document where they mentioned them as a recognized body?
Yeah. Now, in the recent medical device road, they mentioned that we got to get certificate only from IAF member, because it is based on their own assumptions. Because the rule makers, they do not know all these things. By hearing some news from the market, no, it should be IAF member, like that. Even
Right.
they do not have any ground for that.
So basically, I would think, based on what you're telling me, is that your real case is against the regulator themselves. I mean, you will basically have a grievance against the government itself for recognizing a body which has not established itself, or either its presence or its performance in India. That's going to be your first hurdle, and that's going to be the first step that you will have to actually take before making any complaint related to loss of business to the CCI, because the CCI would then, I would think, and it has done that in many cases, to say that this is an issue that needs to be determined first by the appropriate body in the writ jurisdiction, to understand whether the recognition given by the government of India and the decision taken by the government itself is a valid decision.
Okay, 5 years back, even CCI has given one judgment in its appellate panel. They told that for running a certification business, no recognition is, as far as India is concerned, no recognition is available. So if you are having necessary infrastructure, you can do it. Like that, they are given one verdict. Okay. So it is given by CCI only.
Lango, of your challenge also, a mere arbiter in the order cannot be interpreted to say, that it helps you as a business. And if Compat has actually taken that decision, you will probably have to look at the decision taken by Compat and to see on the grounds on which they have held that, because there is the concept of affiliation in India, right? The UGC grants and the affiliations in India are very much prevalent. On what basis has the Compat said that these affiliations are not required by certification bodies is something that you need to look at before you go further, and that's a more individual thing, and we'll be happy to help you if you want to do something in that context.
Okay. I'm ready to do that. Yes.
Yeah.
Thank you.
Sheetal Bharat this side.
Thank you.
Yes.
I just have a comment on this particular query. I mean, first of all, I haven't heard before, like, there is a certification and or body of certification exist when it comes to, I mean, what services Elango is providing. So that's a different. I mean, at least in Mumbai or Maharashtra, I haven't seen that. But don't you see this particular arrangement as a cartelization by the people who are joining that particular association, which is kind of giving recognition to firms like Elango has? I mean, don't you see it's a cartelization, and also don't you see that's a kind of entry barriers for Elango?
Prima facie, if you ask me, Bharat, I do agree that there may be some element of that, but I am just answering Elango's query in terms of the success rate that he may have with the CCI, because he mentioned that there is some kind of government recognition that has been there to this body, is why I raised this question to him, that we need to look at that aspect first before we look at the CCI angle. And I do agree, Bharat, that if you look at it in terms of cartelization, a coming together of several parties and an association which is operating abroad, which one mandates a certification with them on what grounds, I'm not too sure, and we need to look at that, and which requires a single is the single body of affiliation, and which requires an entity to affiliate with them for the purpose of recognition in a particular jurisdiction, would create an entry barrier straight away.
Right. So I actually recall one case which happened a couple of years back that was filed by producer Bharat Shah with respect to, I mean, engagement of certain, I mean, technician or people or junior artist by production houses. So that was, I mean, this is a similar kind of, I mean, case that I see when it comes to that case, like, no, Bharat Shah filing a case with a particular union. So that union is a kind of cine workers union, if I'm not wrong. Maybe you are aware of that particular case. So it's a similar case I see with Elango.
Correct, I see that. Accepting the fact that this has another nuance, that the operating party operates outside India, but that the law is very clear that the CCI can actually, the jurisdiction may not be an issue, because CCI can actually investigate a matter like that. I don't see that as a problem in Elango's case. And yes, like I said, there is straight away, prima facie view is that there is straight away an entry barrier restriction. So it could be a possibility, it could be a good case to take to the CCI, depending on what are the other nuances in the matter.
Thank you.
Right, yeah.
Thank you.
Madam, yes, Sanjay Bhosle here.
Yes, Mr. Bhosle.
I have a question that you had replied to Suman, that if any dealer or distributor is passing on more discount in the market, so company may take action against that dealer. It is permissible. But is it not anti-consumer, that consumer in turn will get lesser discount? CCI may fine to that company like CCI fine to Maruti.
Correct, which is what I was telling Mr. Kumar, Mr. Bhosle, that in the Maruti case, the restriction which was imposed by Maruti on the distributor in preventing them from offering better discounts was held to be anti-competitive by the CCI, and Maruti was actually fined. So it is a decided case that you, what do you say, a distributor or a company cannot actually restrict a dealer from doing that because it is anti-competitive.
So it means a distributor can give any margin to a dealer and sometimes make a loss, use his dominant position and warn out all his competitors.
That is a different test altogether. If it
So
does create, if one, the first question, like I said, is whether the distributor is actually in a dominant position will have to be established.
suppose a distributor is not a dominant position, has a market share of only 10%. Still,
Correct.
he can give a more discount and disturb the market and just to attract more and more customers to him, like a
Yes.
Jio.
Yes, because that would be fair competition, Mr. Muslim.
And
I mean,
for that dealer, if company takes the action, then CCI can catch hold to a company. Why you have taken the action against such dealer?
no, I would not think CCI would have any right.
And
to
exactly
go-
CCI had done with Maruti in the same case. Maruti
No,
fined to the dealer and CCI catch hold of Maruti and fined to the Maruti.
no,
Why you
because-
are restricting your prices?
right. So to answer your question, the role of CCI in this matter was because Maruti actually took a step of being restrictive in nature. It was restricting the distributor from offering these discounts. When you say Maruti took action or you want to take action against a distributor like that, it is held by the CCI that you cannot restrict him from doing his business because he offering these discounts to the consumers will lead to better competition and will lead to better benefits to the consumers. So you cannot restrict him.
So hence you had suggested, you have guided Suman, so you can take action against distributor. So now you are telling
No,
you
Mr.
cannot.
Gossi, I was saying I as a company, and that's what I clarified with him, that I cannot take action as a company. I said, but if the other distributors in the market, through them, I had said, if the other distributors in the market, and this is a strategic planning, right? This is how you advise a client, that if you want to get something done, then other distributors in the market, if they are affected by this practice and if they can show that this practice is actually leading to they losing their customers, losing their business, then they not being able to meet the market conditions, they not being able to do business in the prevalent market because of these practices being anti-competitive, then those distributors will have some case, not the company in itself. That is exactly what I was saying.
Sheetal, obviously, if one distributor is passing on more margin than the current prevailing rate, then automatically other distributors will get losses and the customers of other distributors will come to me if I am offering more.
Correct, and which is not unfair if the distributor himself is not in a dominant position. If he's not, more than 10%, if he has only 10% share in the market, then it doesn't really matter because if you see the larger scheme of things, it is not as if he's going to do 100% of business there, right? The loss of business would be restricted only to his value in the market itself.
And suppose company had fined me, even if I am not at a dominant position, but company had given me a fine of some rupees.
Right.
So can I go to CCI against company?
No. What would be your grievance? Your grievance would be that the company is actually entering into a practice of restricting you from carrying out this action.
Yes, company is restricting me and I am passing on more discount to my consumers. Why company is restricting me?
Correct. Then you fall square within the Maruti judgment which the CCI has just passed.
So CCI,
and you can make that complaint if the distributor is doing that uniformly and if it is being abused in the market and if it is leading to a anti-competitive practice and if it is leading to a loss for the consumers ultimately, then yes, that complaint will be maintainable.
But can I interrupt?
Yes.
The other argument can be like as Sital said, that there are dealers who are complaining that I am not able to do business, and this dealer is using his prominent position. So I can take action, giving the condition that okay, you cannot do this to increase your business and harm my other dealers.
But
If my
I am
dealers,
helping the consumer.
no, you can help the consumer, but you are not helping the other dealers. How you are helping the consumers? You are
Like
using your dominant position.
I am not a dominant. I am a lesser than 10% market share.
No, but then even then you are less than 10%. What market share of the town, of the state, or what, or the India in the
Where I am selling my product in that particular district, I am less than 10%.
But mostly that would be, I think that would be very vague, that we have data on the district wise, the how much market share we have and the dealer has. And the nature of these such complaints, the reason I am arguing with you is because in our business we saw that okay, the dealer is not a predominant in a dominant position, but he may be using the Reliance trick, like he want to enter the business and he is offering some high discount on a known brand to get his product sell.
I
Why
may
should
face, I'm facing losses like Paytm and all, and I'm helping consumers. I may face loss.
no, but as long as you are facing loss, it's okay. But why you are putting me in trouble as a company or as an other?
That CCI allows me to do that.
That's a vague argument, I think so.
Madam, please, you, Seetal, you have to tell me, am I wrong?
No, you're right, for the simple reason is
Then
that
why
the
company should not debit me?
correct, I understand. So when CCI looks at issues like this, the CCI will look at two issues. Like I said, one is whether there is a dominant position. Number two, whether the other prevalent players in the market are affected. But as we have seen in the past, the most important factor that the CCI looks at is the consumer, and whether any benefit is passed out of this fair competition to the consumer. And in more cases than not, CCI has held that if, as a consequence of the practices, correct, of the industry, a larger benefit is passed on to the consumers, the competition itself would be considered fair, unless it is extremely anti-competitive, and it is a complete abuse of the dominant position. So the consumer is definitely God in the eyes of CCI also.
Okay, can I one more small clarification when we are getting into this definition of consumer, Bhosle? What do you mean by consumer? Is the end consumer or the dealer? His dealer. Distributor has a consumer. Is his dealer is also a consumer for him?
Like for example, I will give the example. I took the goods at 25% discount.
Okay.
And to promote my company and to make my good brand, I am a small player. So I had deep pocketing, like 5% losses. And I had sold that at 30% discount to my dealers.
So dealers, that's
okay.
what I...
And my dealer in turn selling the goods to a consumer at a 25% discount. So consumer is getting benefited.
That's a long way to prove. I don't know. I'm not a legal expert, but that's what I said. There are ways to handle these things. Otherwise, then everything will go in the holy cow name consumer. You are allowed to do anything. So anyway.
That is the this law of this CCI.
Nuances. Consumers in the eyes of CCI, I would see, would be an end consumer, and they are looking at a larger population, depending on which is the relevant market we are talking about. So the CCI would look at a consumer as the end consumer, in my view, based on what is the relevant market we are talking about. So it would, of course, include a B2B also, but it largely would include a B2C also. It depends on what is the number we are talking about, what is the adverse effect that we are talking about. whether what is the practice that we are talking about, what is the market share that we are talking about. There are a lot of variable factors involved.
Yeah. Thank you. Thanks, Bhosle, for this
Thank you.
discussion.
Thank you, madam.
Thank you.
Thank you, sir.
So I think just to move on, I will continue with my discussion on certain case laws, if you all allow me. This was a very, very interesting discussion, I would think, and I would love more exchange of that if anybody has any queries before I go on.
No, on the discussion on this topic itself, I was thinking when he said the dealer or distributor, when earlier we used to have a point distributor, and you said that you should review your agreements quite frequently. What time frame do you give basically? See, taken all these conditions and these precautions into the conditions in the agreement, and what should be a time frame to review the agreements?
I think a yearly review is mandated, Mr. Kumar, because when you're looking at business at large, right, your agreements on a yearly, and of course your vendor agreements, etc. I understand in a company would be anywhere for, it is never a yearly agreement. These are agreements basically for 2 years, 3 years, right? So if you
Yes.
take a yeah, so if you look at it from your industry perspective, possibly you should review your agreements once in 2 years. Every single time an agreement is up for renewal, also you must look at the agreement and the terms and conditions, because the Competition Act is an ever evolving law, as we know. So when you review the agreement, you should look at it from the perspective of competition law. When you renew the agreement, you should look at it from the perspective of competition law. So I would think, whilst a yearly review would be very, very, what do you say, diligent, possibly a review at the end of the term of the agreement or at the end of 2 years would be the way in which it would be more practical for industry.
Okay, thank you.
Madam, can I ask one question regarding cartel?
Yes, please, Mr.
There are two brothers with a single brand. They were manufacturing and selling the goods in India. But the brothers divided and then created two different company, company A and company B, and selling the same brand. But both of them decided that I will sell this brand to 10 state of India, and for balance state, you sell the brand. Is it a cartel between company A and company B?
I would think no, because that's only a geographical distinction, right? And the, what would be the relevant market? If in the relevant market they are operating as individual operators, just the mere fact that they have created a geographical demarcation would not mean that they have formed a cartel, unless they are entering into or engaging in certain practices which are actually affecting the competition per se. What is the intent of the brand distribution as such? It's something like a family arrangement, right, where two brothers separate and they decide to operate the same brand in two separate geographical uh, places. So what is the actual effect that you think that has had on competition? What is the appreciable adverse effect that it is likely to lead to?
No, I don't know. Just I had asked the question.
Yeah, and a cartel would, simpliciter coming together of certain entities would not per se under the Competition Act be a cartel. A cartel is when the association, organization, group of people coming together are engaging in activities, right, which would have an appreciable adverse effect on competition.
All right. Thank you.
Right. Let me just see what is the interesting case that we can look at. So we discussed, of course, Maruti. Let us look at Honda CL cars also in that context. So Honda, as we know, is a car spare parts market in India, which is a very, very closed market, right? Where where manufacturers mandate authorized dealers to source their part only from OEM. So this was a different case altogether, or by approved vendors. And these spare parts are not actually sold in the open market, right? Now, CCI looked at these agreements where the manufacturers had mandated the authorized dealers to buy their spare parts only from original equipment manufacturers or by certain approved vendors. And the CCI had actually held that these are agreements which were anti-competitive. It had also held that the spare parts market is a separate market from the car market, and the consumers don't engage in buying cars and going to whole life costing the life cycle is not met by consumers, right? And the car market and the spare part market has to be kept separate as two different and relevant markets, and the car manufacturer therefore cannot monopolize even the spare parts market. And it was also held that via the manufacturers, the OEMs were abusing their dominance by restricting independent repairers and other non-authorized repairers from accessing the secondary market and marking up the prices of spare parts, where OEMs were actually marking up these spare parts by 5,000%, which is a humongous amount, and which was being trickled down to the consumer, and they were not allowing independent service providers to access this market at all. This decision was actually confirmed by the Compact, and the Compact also confirmed that this would be an anti-competitive agreement. It's a very, very important judgment in the sense that it has looked at a practice which has been prevalent for, I think, for several years today in the market, where the manufacturer of certain goods insists that the spare parts be bought from the OEM itself. And it is prevalent in the auto market industry, it is prevalent in the, elevator industry. I think it is prevalent in most manufacturing industry. And the CCI took a very very, very restrictive and very, very, not restrictive, very, very broad view, in the sense that it looked at it from the perspective, as always, from the consumers. And it then said that twofold actually. One is, it looked at whether the spare part market itself is affected by this activity of the manufacturer, and all the spare part industry would also be affected, number one. And number two, at the end of the day, because of this practice of the OEMs marking up their product by 5,000%, was the consumer paying more money than he usually would if you went to buy this spare part from the secondary market itself? So it was a very, very interesting decision by the CCI, where the CCI held that these are restrictive practices. I mean, in terms.
Sorry,
Yes.
Bharat, this side. Sheetal, I just wanted to understand from your side. I mean, you explained this one, like a judgment coming from CCI itself. Do you see this? As an individual, do you see, or as a practitioner, do you see this was really a competitive competition scenario? Because I don't think this one, because as a consumer, say for example, I am the one who is going to purchase a car from a particular dealership. At the same time, I would want to buy certain genuine parts from spare parts from that particular dealership. So if I don't want to buy those spare parts from that particular dealership, I'll go in an open market and I can buy from there. So I have a liberty to do so. But as a manufacturer, car manufacturer, that car manufacturer should have that kind of rights, exclusive rights, and making it mandatory on the part of a dealership that they should not sell anything which is not genuine. So, I mean, I just wanted to know your perspective or your thought on this one.
Right.
Because I
See,
don't see science company.
Can I add one more thing on the same thing? I had also the similar thing. As a manufacturer, I can argue against this. Why I will take a responsibility of a substandard quality of a spare part that can jeopardize the performance of a product. Take an example, anything. You take a pressure cooker, okay? And I would argue that you should use the genuine spare parts. Suppose you take substandard parts from an open market. How will I be responsible for the functioning of the pressure cooker over a long period of time? For example, the car thing. So I have a different view on that. I don't know how this you can say that the company cannot enforce it. But how can I take responsibility? Suppose you are a consumer and you come after 3 years and say that, okay, I have used these spare parts and the product is not working as you had guaranteed. I will counter you back that, ma'am, you have not used the product or parts as I had explained, because I cannot control the quality of the third party which are supplying.
Correct, which you are welcome to do. So you are right. In this case, what had happened is that a mere restriction on the distributor for buying from the OEM was not the only consideration. The consideration in the present case, and why the CCI took this view, was because due to this advantage of this restriction from buying from OEM, the OEM were marking up the prices for more than 5,000%, which actually led to the consumer paying for it and paying for the entire life cycle of the product itself. That is what the CCI held was to be anti-competitive as an agreement, is because it is actually having an appreciable adverse effect on competition as well as the end consumer. Had the consumer not have to pay out of his pockets this bigger markup, all of you are right, possibly. But they looked at the facts to see that, yes, there was an abuse of this position that the OEMs were put into by the manufacturers. And as a result of the abuse of this exclusive position that the OEMs had, the consumer was ultimately, paying for this entire life cycle, but, to the extent of 5,000% as a markup for the spare parts, which otherwise it would get for much cheaper into the market at their own risk, of course. Which is why the CCI led to this decision. Had there been no markup, had there been, no abuse of that dominant position by the OEM, possibly no, then it would not be a restrictive practice.
No, but there would always be a markup. That is a very judgmental question. If somebody is making up, and if you are manufacturing the same spare part in somewhere in a small manufacturing facility, your overhead would be less. So,
correct, I understand that. But what is the extent of that and what is the effect of that on the consumer itself would be a question which is very relative, right?
Yeah.
And whether it is actually creating, if it is creating a difference between 100 and 5,000, then there is definitely an appreciable adverse effect. But if it was creating a difference between, say, 4,500 and 5,000, possibly the CCI would look at it as fair competition. Because competition in itself is not restricted. We should understand that the competition and holding a dominant position or entering into agreements which are restrictive in nature or exclusive in nature in themselves are not anti-competitive. But as a result of entering into those agreements, if you're creating a scenario which will ultimately lead to anti-competitive practices, which would ultimately lead to a consumer being affected by it and not being able to avail the benefits of fair competition, then the practice would be anti-competitive. Not per se, like exclusive agreements per se are not anti-competitive. But as a result of that, if it is creating an entry barrier, then it will be anti-competitive. So you have to look at it holistically from the relevant market perspective. Of course, it's a very open to debate question. It will be very relative. It will depend on.
I was about to say it's very open to debate, and I am not fully in agreement to this, because see what happens when suppose this Honda company, if I send my car to a Honda service center and I argue that no, you give me some cheap parts, how will they take a responsibility? Something tomorrow goes wrong, and I sue Honda for being not good quality parts or having malfunctioning the problem in my car. So it's a very I am not very convinced with this that
which
you
is
can't.
why, which is why I was saying what the manufacturer has done with the distributor, right, is fundamentally the right thing. But the advantage the distributor has taken or the OEM has taken out of this arrangement, which has ultimately affected the consumer, is what is anti-competitive. So these are two moving parts, right? One is whether the agreement in itself is anti-competitive. If you see the agreement stand alone, it's not anti-competitive, right? Because it is understood that if Maruti is selling a product, it would want its OEM to buy these spare parts from them, right? So that when the servicing of the product happens, the right parts and the original parts are going into the vehicle itself, so that ultimately even the consumer is benefiting from it, from having original parts and not being fooled by other. But because of the fact that the OEM had this arrangement, if they mark it up a 5,000%, then they're creating, you know, actually a price variation for the purposes of the other secondary markets, because there is a prevalent secondary spare part market, as we know, and therefore the relevant market for the purpose of analyzing anti-competitive practices is very important. And the CCI held that look, a car market is a different market altogether, and the spare part market is a different market. And in that particular market, there is a secondary market which is prevalent. There are players in the secondary market. Those players are also affected, as well as the consumer being affected, as a result of this particular restrictive practice, in light of which it held that this is a anti-competitive agreement, not standalone as a practice itself. And that practice is very prevalent in all the manufacturing industries today. I think still people are entering into these agreements despite the order passed by the CCI, because in itself it is not anti-competitive, and this is a 2011 order.
Okay, just one your view on one topic. Suppose I have given a guarantee to a customer for a product performance, okay, and he uses the product, and in between he has changed some spare parts, and he is not using the correct parts, okay. Can I refuse his guarantee?
Yes, those are violation of the guarantee conditions. That's a separate argument altogether. You definitely can. And that is
Okay.
definitely not anti-competitive, right? Because your warranty and your guarantee is based on certain particular conditions. One of the
Yes.
conditions being that you will use only original product, and it's a very, very standard condition in a guarantee and a warranty, that if there is any deviation from, the products that are being used for the purpose of servicing, repairing, etc., then the warranty itself lapses, right? So that's a
Yes.
violation of the guarantee condition. You can most definitely refuse in a case like this.
Okay, thank you.
Right. I think, with this interesting discussion, we should bring, I had other case law that we can keep discussing, but I think the CCI and the Competition Act is an act which is, open to interpretation. And there's several subject matters, several industries that CCI has looked at. And it is actually, so to sum it up, the CCI has to look at several, one, the act in itself has a lot of factors that need to look at. um, the agreements per se, which are restrictive in nature, exclusive in nature, which has specific arrangements between parties, are not anti-competitive as long as they do not cause any appreciable adverse effect on competition and ultimately on the consumers. Number two, for the purpose of determining what is the abuse of a dominant position, one, there has to be an establishment of a dominant position, and number two, the dominant position has to be abused by the party itself. to create an anti-competitive environment. And of course, the ultimate effect of that on the consumer is what the CCI has to look at. Cartelization, we have seen the formation of a cartel per se would not be anti-competitive. The cartel and the activities that the cartel is engaged in has to result in an appreciable adverse effect on competition, has to result in abuse of dominant position, has to result in the consumer actually being affected by the activities at the end of the day. And combinations, when it comes to several combinations, we've looked at what are the combinations that the CCI will look at, what are the horizontal agreements, vertical agreements, what are the combinations that require CCI approval, what are the thresholds which will lead to a combination requiring CCI approval, and what are the agreements and combinations that will not require the CCI approval. So that is the gamut of the entire discussion I think we have had today, and some interesting case law being discussed. But I think we can sum it up by saying that each matter and each inquiry to the CCI would be largely based on an investigation of abuse of dominant position. Again, I mean, I'm being repetitive, but just to sum it up, abuse of dominant position, your appreciable adverse effect on competition, and the ultimate result of the actions and the agreement on the consumers at large. So I would like to sum up, I think, today's masterclass to say that consumer is God. Unfortunately, we are all in the business here, but that is how the CCI has looked at it largely. Yusuf, Samina, I think we can close this successfully. If anybody has any other questions, etc., we'll be happy to discuss some more. I think we have another few minutes left. And I hope that all of you have had a good session. I thought the afternoon session will be more sleepy, but I'm glad there was a lot of exchange of ideas and discussions that took place. And I hope some clarity, I could throw at least some light and give you a few clarifications which you can take away.
Yes, surely.
Thank you.
Thank you very much, madam.
And any of you, of course,
Sheetal,
and otherwise, are very welcome to reach out to us for individual questions. Like Mr. Lango, please, we'll be very happy to assist you and look at your relevant questions and look at whether you can do something with the CCI, etc.
I have one question, Sheetal.
Yes, yes, Bharat.
So when it comes to this entry barriers, what if government itself is kind of creating entry barriers for the new players to come in the market? Just to give one example, say for example, if somebody wanted to get into like broadcasting business, wanted to have some channels of their own company and get into broadcasting into entertainment maybe, or any other channel such, so they are like required to have certain revenue, like say 5 crores, if I'm not wrong. So that kind of entry barriers created by government itself to the new players. So how do you see to these entry barriers, and whether CCA can do anything about it? I'm just generally asking.
See, a public sector undertaking, Bharat, to answer your question, would fall into the purview of the CCI. The CCI can look at, I mean, coming to the first stage of whether a public sector would at all be subject to the CCI jurisdiction, the answer to that is now yes. So the public sector will form under this. Now, when it comes to entry barriers, as regards the business that particular person has done, most definitely, I think, you need to look at first what are the conditions which are laid down, what are the circumstances in which those conditions are laid down in relation to the particular industry. And I have very little information that you've given to me that they would have, and this is a barrier which is there possibly in all kinds of industries. And I do give analogies of airline industry very often, because I have advised a lot of airline clients and I do belong to the aviation industry. If you see in the aviation industry also, international, you can fly international only after you have 5 aircraft. If you have flown n number of hours, etc. So all of these barriers, or you can say conditions, I can't, I mean, I don't know if we can strictly call these entry barriers.
Okay, okay, okay.
Because there would be, like, even in the airline industry per se, and we have to look at the case that you have told us in the particular relevant market, whether there are any other conditions for new players and what are the SOPs given to the new players. Because in every industry there would be possibly, you know, a kind of an entry barrier or conditions that you require to meet to get to a particular level. Even for tenders, as you see, you would probably have to have business that you have done. You have to, show that you have done n number of contracts, etc. All of that, if you prima facie see, would be considered a entry barrier for a new entrant, right? But these are the conditions that you have to comply with. So it will be very individualistic depending on what is the relevant market and what is it that the relevant market caters to, and plus what are the SOPs that are given to the new entrants into the market, and what are the conditions for the prevalent existing parties in the market.
Since you have talked about the airline industry and you said that you have advised a lot of airline, my just thought and query, it's not, it's a just a curiosity that with the Tata buying Air India, now they have the two companies, Tata and Indigo. With the Tata, Vistara and Indigo, they will have more than around 65% market share of Indian aviation. Will not this create the entry barrier, or somebody can challenge this?
No, I would not think so. It is not an entry barrier for the simple reason that other airlines like Akasa, several other airlines like Jet Airways is reviving itself. Akasa, in fact, it is promoting more competition, I would think, in the industry today.
But with the 70% market share, cartel can happen.
Cartel can happen, but whether there is an existing cartel, most definitely an airline is a industry which is very, very sensitive to cartelization. And I can tell you as an insider that there is a lot of cartel which is being investigated by the CCI in relation to pricing norms, etc., by the airline industry. That it does happen. And you're right that the acquisition of Air India by the Tatas and the Tatas being prevalent in the market already, plus Indigo being the biggest player in the market, there is a likelihood of more cartelization, more price variations, more price manipulations, most definitely, most likely in this industry today.
Thank you.
Hi Sheetal, this is Priyanka here.
Yes, Priyanka.
So I just have a question which is more kind of a curiosity question which I had. So I am into an industry wherein my customers are the company. So it's basically a B2B business. And to have to have insights of my customer service team and to give more enhanced customer service to my customers, I decide to conduct a survey wherein I'll appoint a third party agency to conduct survey and ask questions to my customers who also buy goods from my competitors. So here in this survey, I decide not to ask some price or any sensitive information, but some information which obviously relates to my customers, say my competitors. Say for example, how is their turnaround time on the issues or complaints being raised, or how the packaging is, or I mean similar questions. So will that will I be brought under CCI radar for this activity of survey?
So, based on the information that you've given to me, it appears that you're collating information related to competition, right?
Yes.
So, and which may not be strictly price sensitive information, and you're collating it from vendors who have relationships with the industries themselves. So, as a first stage, I would think that the vendors are obligated not to disclose this information because they would be covered by a NDA and a non-disclosure agreement vis-a-vis the companies themselves. But if this information is such, and it's not really a anti-competitive practice if the information as such is basically public information that is largely possibly available in the market or through sources, or is disclosed per se by the vendors themselves, I would not see how the collation of this data in itself will be anti-competitive.
So I'll tell you, it's more kind of an experience which the customers are having from by buying materials from me versus buying it from my competitors. So it's more on the experience which they have, and I'm just doing this survey, to enhance and provide better service to my customers. So the intention here is very clear. So I just thought, will that be brought, because competitors here are involved and obviously data is there.
Correct. So just mere, like I said, I would see prima facie just mere collation of data from your vendors related to the products and the services given by other competitors may not be anti-competitive per se, unless it is used to the detriment of, competition itself. I mean, you can enhance your product, but that cannot result in really an anti-competitive practice because you have collated this data from, vendors who are working with several other manufacturers. Correct. So that may not be anti-competitive, and the collation of this data in itself should not be anti-competitive for enhancement of your own product or service.
Understood. Thank you so much, Sheetal.
You're welcome.
Sheetal, I have a question. Supriya this side. I wanted to understand this concept of algorithm collusion. I know it was explained in the first session, but not very clear on it.
Sorry, the terminology you used was, sorry, Supriya?
Algorithm collusion. Algorithm collusion.
Okay, more a subject for Samina to take. Samina, you want to take that question? She is more savvy in the digital area, let me tell you. But from my experience, before Samina takes this, the algorithm collusion is the kind of collusion I was talking about vis-a-vis the airline industry, where you use a particular algorithm to understand the requirements of the market, right? To collate the data related to the search engines and what is being entered into the search engines, and then use that data to manipulate the pricing of the product.
Okay, so it's like a common algorithm which all the players are using, and that is how the prices, change for each of them.
Yes, there are actually softwares which most of the industries would use. I mean, at least in an airline, I can tell you every airline has this algorithm through which they will get, that is how they get the data related to how many consumers they have, what is the most lucrative route, what is the most, what is the price that they should fix for the purpose of a particular route, etc. And I'm sure that is prevalent in all the other industries also. These are algorithms that are commonly used by industry.
But Sheetal, I mean, most part of it, the companies get also through, primary and secondary research. They collect this data through the research, and I mean, this is very much normal. But the running an algorithm and, getting it done, and so consumer is not getting any benefit out of it, right? So for me, if I'm trying to travel just because of the search, the prices is going to increase. So, from the point of a very common consumer, this is not in favor of a consumer. So how come? I mean, this is such a common thing as well. So how come CCI has never looked into it, or there has not been any sanctions for it?
To my knowledge, CCI is investigating these issues.
They
It
are.
is. They have already raised an issue in relation to the abuse of algorithms.
Okay, and is it
And
some?
Samina can elaborate on that, Samina.
Yeah, thanks. So, these technology tools and big data as it is coming, as I said, that CCI is one of the more progressive regulators, and it is going up to checking the IP addresses when it is doing an investigation. So as Sheetal rightly said, there have been cases which have the investigation is in process, and it can take up to almost 7 years, because the investigation is just not based on documentary evidences. So the investigation done by CCI is generally, a very end-to-end detailed investigation. So in cases of algorithm collusions which have come up before the CCI, specifically as I mentioned in cases of Uber, Ola, where there is predatory pricing, and one of those reasons for predatory pricing is the algorithms that they are playing with, or they have in place. Also, what Zomato or Swiggy is doing, there's a lot of data based on how the user is using, or the lifestyle of the users through which they get a lot of information. They are taking a lot of data, and with that, the companies are using it to their benefit. So as of now, there is no order per se which we can give you reference to, but there have, the investigations are going on, and hence this whole algorithm collusion, even this topic has come into play and enforced, so that we should take care of, because you never know. Today there is nothing as such, but tomorrow CCI could be one of the first regulators to come up and stop, or to come up and give an order where this kind of algorithms should not be used.
Thank you. Thanks for the explanation.
No problem.
Right. I think, Yusuf, we are very much in time to close this session. And I must say that I have enjoyed it.
Thank you so much, ma'am. Thank you so Samina ma'am and Sheetal ma'am.
Thank you so much to all the participants and being such active participants. That's great.
Thank you so much.
Thank you.
Thank you.
And thanks, Sheetal.
Thank you. Thank you so much.
Thank you very much.
Thank you. Thank you very much.
Amit. Amit, will you share PPT with us?
Mr. Bharat will get in touch with you for sure shortly. We have got your query, so we'll get in touch for sure.
Thank you.
Thank you, Sheetal ma'am. Thank you, Samina ma'am.
Thank you so much.